Your Honors, good afternoon. If I could reserve 4 minutes for rebuttal.
All right, sir.
So may it please the court, my name is Jay McLemore, and I'm of the Williamson County Bar, also Nashville Bar, and I have the privilege of representing Allstate Property and Casualty as the appellant in this appeal. And Your Honors, this appeal is over the denial of a MedPay offset that occurred post-trial in the 15th Judicial District. I was not counsel in the lower court proceedings with Mr. Agee, but you have the transcript filed as Volume 2 as part of the appellate record. But the bottom line is the trial court denied a $5,000 MedPay offset and ordered the carrier to pay that additional $5,000, and that's why we're here today. It's a brief background. This is a personal injury case and involves Mr. Agee's client, Mr. McCoy. Unfortunately, back on, I believe it was September the 7th, 2019, he was rear-ended by Miss Katelyn Conway in a van owned by Cortland Douglas. She was intoxicated. So Mr. McCoy then filed suit on January 22nd, 2020, and Allstate filed their answer February 26, 2020. The reason I raised that is in that answer, Your Honors, Allstate raised their right to an offset under the policy and also under the Tennessee statutes as the third defense. In the sixth defense, it was a little more particular. They raised the right to recover $768 of payments issued to Mr. McCoy, but I don't believe that check had been cashed at that point. Discovery proceeded, and on November 3rd, trial was set for April 13th and 14th, 2021. On December 20th, 2020, payment for $5,000 MedPay was made by Allstate to Mr. McCoy. Trial proceeded on the 13th and 14th. Mr. Douglas and Ms. Conway never filed an answer. They were uninsured, and they didn't appear for trial. Allstate appeared as itself. The jury rendered a verdict for $80,000 compensatory and $40,000 in punitive damages. The punitive damages were against Ms. Conway. Compensatory was against both the owner, Mr. Douglas, and Ms. Conway, the driver. On April the 20th, a $45,000 check, April 20, 2021, 6 days after trial, was transmitted to Mr. McCoy for $45,000, which is the remainder of his $50,000 per person uninsured motorist bodily injury limit. May 25th, 2021, the instant motion was filed to compel an additional $5,000 for the full $50,000 limits. Allstate contended, wait a minute, we've already paid the $5 plus the $45, we get an offset under the law. Well, that's the whole issue we're here about. So this was argued in the 15th Judicial District before Circuit Judge Collins on July the 12th, 2021, and an order compelling the payment of the extra $5 on July the 15th. We were substituted as counsel, and the appeal was filed on the 12th. And of course, the reason we are here is that, and Your Honor, as the appellant, with all due respect for the trial court, I believe error was made, and that ruling, post-judgment ruling, needs to be reversed.
Was the med payment made pursuant to the Appellee's own medical payments provision of its own policy?
Yes, Your Honor, under Allstate's policy, the medical bills he submitted.
Which is a separate provision. It has that's its own provision within.
It's its own coverage, yes, Your Honor, with its own premium. It's no fault coverage, and in other contexts would provide for payments to the insured. Regardless, right? Regardless of fault.
And regardless of whether or not there was an uninsured motorist claim made.
Yes, Your Honor.
And regardless of liability.
Yes, no fault. Yes, Your Honor, that's true.
The UM statute says that the limit of liability would be for the amount of coverage specified in the policy less the sum of the limits collectible under all liability and or primary uninsured motorist provisions.
Yes, Your Honor. I think that's 1201D that Your Honor was reading from?
Yes.
Yes, Your Honor.
So does the MedPay provisions as separate coverage come within those provisions?
We would assert that it does, and also...
I know you're asserting it does, but my question is, does it?
1205, yes, Your Honor, and then under 1205 especially, where you allow for the offsets. And then under 1206I, Your Honor...
Is MedPay is not, you've already said MedPay is regardless of liability.
It can be claimed Right, no fault.
regardless
Yes, Your
of
Honor.
liability.
Yes, Your Honor.
And it doesn't come under the uninsured motorist coverage.
Well, the uninsured motorist coverage can offset it, but it's a separate coverage. Yes, Your Honor.
Well, that's what we're here to decide.
Yes, Your Honor.
But it's a separate provision. It's not under the uninsured motorist provisions.
That's right. It is under Part 2 of the medical payments coverage in the policy. But there is a non-duplication provision contained within that medical payments provision.
But how is it duplicative if it doesn't come within either the liability provisions of the policy or the uninsured motorist provisions of the policy? It's a standalone provision. It's collectible regardless of liability or uninsured motorist.
It is collectible. It is collectible as no fault, but Your Honor, it's the reason that it's because it's for bodily injury damages, for medical damages, as part of a bodily injury claim. And the statute, along with the policy, allows the uninsured motorist carrier to take credit or offset for amounts paid under MedPay as part of the $50,000 uninsured motorist limit.
Well, what I just read under this statute doesn't say that. It says under all liability and or primary uninsured motorist insurance policies.
Yes, Your Honor. But if you come to 1205, it talks about in the limitations for uninsured motorist policy for the limits, it allows for the carrier to take an offset for other benefits paid. And I'm just going to read the last sentence of that. It says the forms of coverage under UM can include terms, exclusions, limitations, and conditions, and offset that are designed to avoid duplication of insurance and other benefits. And in this case, we're talking about medical benefits that are part of a bodily injury claim. And so therefore, pursuant to that statute, and I was going to mention a case that we found late from 1970 where this came up. It was a case that we had a difficult time finding because it was an unreported Supreme Court case, but it is quoted in Terry versus Aetna Casualty, where the Supreme Court looked at this in 1970 from an appeal from Davidson Chancery, very similar issue with State Farm, and State Farm had paid $20,000 in UM benefits. And in that case, the decedent's Kennard, through their administratrix, Ms. Jenkins, said, wait a minute, you've paid the 20, but you also owe us for medical payments because that's a separate coverage. And addressing some of the concerns the court's raised today, and in that case where the Supreme Court affirmed it, the court said, no, this is allowed under the old version, which I believe is 561152, but it's now the 56.7.1205, allows the carrier to take offsets for medical payments and coverage payments that are made as part of the UM coverage. Because it is medical payments coverage, and Your Honor is correct. But because of the statute, Your Honor, what the Tennessee Supreme Court and the legislature is allowed, the carrier is allowed to take credit for that. And that's what we're talking about here today.
Have you cited that Supreme Court?
Your Honor, we did, and we had to file it, unfortunately, Judge, as a supplement, which we did today. Okay. And I apologize. This is in the Tennessee Automobile Liability Insurance, Section 18.2, cited in our brief that supports that carriers have the right to MedPay offsets. And this same provision that carriers have the right to MedPay offsets is also cited in Powell versus Clark and in other decisions from the court. And that's, Your Honors, that's the Fleissner-Campbell Treaties, Tennessee Automobile Liability Insurance, and that's Section 18.2 for that. So, Your Honors, under both the statutory provisions, especially 1205, and also, Your Honor, I was mentioning 1206I very briefly for my time, but 1206I allows UM carriers entitled for credit for the total amount of damages collected by the insurers from all parties alleged to be liable. And we would also contend 1206I provides an alphabet because Allstate Property and Casualty is sued as an unnamed defendant in this lawsuit. Moving on to the policy itself, briefly mentioned the UM endorsement that allows for the damages payable. That's if you in the policy on record, you have the limits of liability under the UM endorsement, and the damages payable under that are reduced by medical payments as per the terms of the policy, and then the non-duplication provision. And Your Honor, quickly, Terry versus Aetna Casualty, a very old case, but if the court decides with Mr. Agee and Mr. McCoy, then I would submit that decision was erroneously decided because in that case, the total award was $100,000. Mrs. Terry's husband died. She had a $10,000 UM, and she received $10,080 of workers' comp insurance. And the Supreme Court looked at this, and they also cited this very hard-to-find opinion that we found, but the Supreme Court opinion from 1970, that this is a limited benefit state. And therefore, the offsets are allowed under now what is 56.7, 1205. And from what I can respectfully get from what Mr. Agee's arguing, that his contention is, well, wait a minute, no, until you don't get offsets because the damages are more than the limits, and therefore limits should match. He paid a premium for this, and therefore you can't get the offset. And that goes against the Green versus Johnson. We've got this in our brief, but the Green versus Johnson case and many other cases and this other supplemental decision that I submit to you. So for those reasons, all states should have been entitled to their MedPay offset. In the Powell versus Clark opinion that you have, and I know Mr. Agee will discuss that, that's a very different situation where you had two policies and the State Farm did not apply. But if you look at that case, the $2,000 offset from MedPay by Allstate was allowed by the trial court and the Court of Appeals. That's what we have here, and therefore respectfully submit that the trial court's decision needs to be reversed. Thank you, Your Honors.
Thank you.
Good afternoon. I'm Neal, Agee of the Lebanon, Tennessee Bar. Pleasure to be here this afternoon. I represent Mr. Christopher McCoy at trial and in this appeal. Respectfully, there's a little bit of background about this. This case sets this issue up directly and fairly, and there is a jury verdict that this court has to consider. And we do respectfully argue that they are not allowed to have this offset and that the trial judge properly decided this case. In the trial court, there was an $80,000 compensatory verdict. It included claims for past and future pain and suffering, loss of enjoyment of life. There were no claims of lost income. There was a claim of permanent impairment, and all of the compensation that was awarded, none of that compensation included any medical payments, any medical expenses, or any loss of earning capacity. We didn't claim those two elements of damages. Clearly, in this case, Mr. McCoy has a jury verdict that establishes the value of his damages, his compensatory damages, at $80,000. There was no uninsured motorist statute in Tennessee prior to 1967. The first version of this act was passed in 1967. It was public chapter number 371 of the chapter number 371 of the Public Acts of 1967. It was a very brief, very brief statute at the time, and that is the version of the statute that was construed in the Terry case. This Jenkins case that counsel for the Allstate has furnished you today, I actually received that literally as I was walking in today. And that's an unreported case. I've never had an opportunity to read that case before I sat down during an argument in the first case in this court's docket today. But respectfully, the statute as it existed at the time of Terry and this Jenkins case that they're citing is a far different statute than the statute we have now. The statute that we have now has been amended many, many times, and effectively it's been reversed. And when I say reversed, in the original version of the statute, insurers were only required to offer coverage in the statutory minimum limits amount. In other words, if you went to buy an insurance policy and you wanted to protect yourself from liability in the amount of $100,000 back then, which would be, I guess, $1 million, $2 million today, you could not force your insurance company to sell you a policy in an equal amount. They were only required to sell you a policy for the then state minimum limits, which was $10,000. And there was language about offsets as long as it didn't take that coverage below the state minimum of $10,000. So I guess in theory, the insurance company could have sold you a policy for $50,000, $100,000 of UM, and then if they had offsets, the law would have permitted them to offset it down to the $10,000 limit. That might have been permitted by that law. The law was amended, and it was amended, it's been amended many times, but particularly the part about liability that UM has to be offered in an equal amount to liability was in the public chapter number 697 of the Public Acts of 1974. And that was when the legislature, the General Assembly, changed the law and said they had to offer you equal limits. So basically, and at that time, you were basically, and today, you effectively can't buy more UM than you're buying liability. In other words, if you think I need to be protected to the tune of $250,000 per person in case I run over somebody, I can't buy UM coverage to pay for my injury or damages of more than $250,000. The law is very different. The statute is very different. The statute has been amended multiple times in multiple places. You'd have to go back and read the first act to compare it. Literally, it was about 6 chapters, about 6 paragraphs, compared to the current version of the Tennessee Uninsured Motor Statute that covers from 1201 to 1206 in multiple subparts. We do respectfully submit that the Powell versus Clark case, which was a trial court decision out of Murfreesboro by Chancellor Corlew, is very relevant because it does address what has been adopted by the Tennessee Supreme Court in multiple other cases and the Tennessee Courts of Appeals in other cases in the years that this act has been in place, and that is that offsets, no matter how artfully drawn in favor of the insurance company, are not valid and enforceable if they conflict with the statute. The statute as written now, not as written in 1970 or 1972, but as written now, the statute that becomes the contract. And so in the Powell case, State Farm paid a large amount under a medical payments benefit. They paid about $68,000, about that amount, out of $100,000 of med pay. And they paid that before there was a verdict, before the trial court made a decision. Allstate, that was primary because this person who had the State Farm med pay and the State Farm UM was a passenger in the automobile that was insured by Allstate. So there was no question under the state law that Allstate was primary. There was no question under the state law that State Farm had paid $68,000 in medical payments benefits. And the trial court, and then later the Court of Appeals affirmed, said clearly, by the terms of the contract, Allstate is entitled to this offset. And the court basically said, and that conflicts with the statute, because if you give Allstate credit for that $68,000, then their liability as the primary UM carrier was only going to amount to $32,000. They were going to get off the hook because State Farm had made that payment. And Chancellor Corlew did not allow the offset. And on appeal, the offset was not allowed. The point of that is that the statute itself is what controls this. And the statute as it currently is written in 1205 states that they have to offer limits of coverage equal as liability coverage, and they can only have such offsets as would be permitted to prevent, or not permitted, but only such offsets as would prevent duplication of benefits. And in this case, there is no duplication of benefits. This gentleman did not receive more money than he was entitled to receive, and will not receive more money than he is entitled to receive under the judgment of the jury if he receives the full $55,000. This line of, and I will say this case is important because it clearly says the statute overrules the contract, and the contract provisions don't prevail, which is really contrary to this case of Jenkins that I've seen handed to me in today, and it's.
Does it make a difference that you didn't make a claim for medical benefits to the jury? Is that?
I think it makes it clearer that there's not a duplication of line item damages. It is also, though, clear that we received a verdict well in excess of the policy limits. And so even, I think where offsets come into play is when the judgment is for less than the policy limits. Mr. McCoy is entitled to be paid the benefit that he purchased, and that he purchased that benefit $50,000, and the state law does not, in the language of 1205, which is the only statute that mentions offsets, MedPay is mentioned nowhere in the uninsured motor statute. Those words do not appear.
So are you saying it makes a difference because the verdict was greater than the amount of the coverage, or or does it make any difference? Let's say you got a verdict for $45,000. Would you not be entitled to collect based on what your argument is, $45,000 plus $5,000?
That's not the facts, Your Honor. But having said that, I think that in that case they would have a better argument that we were getting a duplication of benefits.
So you're saying then it's what, like part of similar to the made whole doctrine?
Well, Your Honor, there's a lot of case law which I've cited, and there's some opinions that you've participated in that say to the effect that this coverage is to provide the benefit as if he had been run over by somebody with the same amount of coverage. There's a quote in my brief on a case you participated in. I didn't know that when I cited it, obviously not knowing who's going to be on this panel. But having said that, that particular, that point, and I've kind of lost my train of thought here. What was your question?
No, my question basically is I'm trying to straighten out these theories in my mind that you've presented, because it seems to me that the fact that you didn't make a claim for any medical damages to the jury, and there was, I assume, a line item verdict and it didn't include any medical damages, that those would be covered under the UM coverage based on the coverage. In other words, you're not saying it makes any difference whether or not you claim medical damages as to whether or not the medical payments would be covered under this, or it just doesn't make any difference? I'm just trying to clarify that in my mind.
And to answer the question, if we had sought a judgment and for medical expenses, if we'd had a line item in there, then it would, I think it would have still exceeded the amount of money that the policy limits would have covered. And now we're talking about a hypothetical, but I don't believe that it would have resulted in a duplication of benefits. In other words, if we'd had 5,000 of the 80 that was denominated as medical expenses, and we would still be claiming the 50. Does that make sense?
Yeah, so you're still saying that the liability coverage and the med pay coverage would still be less than the 80,000?
That's correct.
And
That's
I
correct.
mean, essentially, your theory is that there are different coverages.
That is correct. That's an essential part of our theory. They are different coverages.
That they're not duplicative,
They're not duplicative. And
and you paid for both coverages.
we paid for both coverages, and state law says that they shouldn't be able to use offsets to reduce his coverage less than the $50,000. I'll make a point real briefly because I'm about out of time.
Before you do that, so how are you treating this $5,000 then? Where does it go in this analysis? You're saying you're entitled to $50,000.
Mm-hmm.
Where's the $5,000 come into?
They paid $5,000 in med pay before the trial.
I understand that, but.
They paid
so
$45,000 after the trial.
what's the total liability of the UM carrier here?
The total liability of the UM carrier, Allstate, for UM coverage is $50,000. An amount that is equal to his liability
So
coverage.
you're saying you do not take the $5,000 med pay into consideration?
I'm saying, and the trial judge agreed, that you don't get to offset that and reduce that to say, you're only gonna get 45 of UM and 5,000 in med pay.
So even though and I'm assuming the contract says this, that you've got med pays under the UM, is that correct?
Med pay is not under UM, Your
Okay,
Honor.
all right.
Med pay is a separate line item,
Okay, separate line item. Okay,
and that's set out in the statement of facts.
all right. Thank you.
And I'm out of time, unless someone has a question, I guess. And then you can. Thank you very much.
Thank you, Your Honors. To address some of these contentions, the statute under 1205 clearly allows for these offsets. In the Powell case cited, Your Honors, that has to do with State Farm, who's an excess UM carrier with $100K in med pay coverage, which is quite a lot for med pay. And they ended up paying early. Allstate was the primary carrier, so that was a situation where you had two carriers, and this was Judge Armstrong's case. And what ended up happening is the court said, and rightly so, that State Farm, since it has 100 that matches Allstate's, it has no liability in this case. And it paid, it was actually right, $70,000 to its insured. And Allstate tried to say, well, hey, we'll go take that and credit that as well. And so that's where the court said, no, you've got a situation where you've got two med pay coverages, you've got two, you can't offset a non-liability carrier. And you'll see the specific wording in Powell versus Clark that State Farm had no legal responsibility in the case. But what you'll also see is that the trial court and the Court of Appeals upheld Allstate's credit for the $2,000 in med pay made to Mrs. Powell originally. So in other words, where they said you can't take credit for State Farm's payment, they're an excess policy that didn't have any exposure in this case. Allstate is allowed credit for its own $2,000 med pay that you have here. And Your Honors, this is the same situation we have here. This is part of the policy. It is part of what is clearly written under the UM endorsement for where they're allowed to take an offset under 1205. The other cases I would cite to you is, to rebut this, is the Sims case that's cited in our reply brief. But similar situation there, where the overall verdict was around, I think it was around $170,000. And when the trial judge came in, and this is a case that had come down to the Court of Appeals, had gone back down and was coming back up, because the trial judge took the overall judgment and not the farmer's uninsured motorist limit and started subtracting off the judgment. And the Court of Appeals came back and said, no, wait, you don't do that, because you have a damages payable section in the policy, and it goes from the UM limits, and you deduct from the UM limits, not the overall judgment. And what's being asked to do here today is to turn Tennessee in not a limited benefit state, but a broad benefit state, so that you come on the damages and you look, what is the total damages? Not what the coverage is and what the offset provisions are, but what's the total amount of the damages. I would also point out in my limited time that while 1201A1 does require that the limits match the liability limits, you do have under 1201A2 the option in writing to get lower limits. So the notion that this is automatic, the statute requires it, it's a must, you have the option of getting these limits. Now, Mr. Agee is right. I don't believe carriers will write more than they will liability, and he's correct on that. He's also correct on the fact the statute has been amended many times. But, Your Honors, this provision has not changed, and it's in Powell. The other thing I'll say, my closing time, is in Green versus Johnson. It's another case in our brief. The verdict was the judgment was $4.65 million. This court still allowed, because one of the defendants had made a settlement and it exceeded the policy limits of the injured plaintiff, her It was a similar situation where she was injured by a drunk driver and an owner who had no coverage. She sued them along with the pub that gave them alcohol because they were drunk when they hit her. That verdict, the court still allowed for the offset because it wasn't the $4.65 million verdict that you make it from. It's what are the limits, what has she received, you get the offset. Pay is the same thing, and that's why I request respectfully that this court reverse the judgment of the post-trial judgment of Judge Collins and allow the offset. Thank you, Your Honors.
Thank you, gentlemen. We will attempt to get you an opinion at the earliest possible time. May call the next case, please.